Good morning, this is your Kelso Report for Tuesday, January 22nd. I'm your host, Clark Kelso. Well, last week the 3rd District weighed in on the technical processes used by the legislature to enact a budget, along with enacting its trailer bills. The 5th District took a look at whether a police officer has a mandatory duty to report his own acts of sexual abuse of a minor. And the 4th District explored what it means to attempt to possess an unlawful assault weapon. We begin with the 3rd District and the budget process. The processes by which the California legislature actually considers and enacts the budget is much more complex than people realize. Until recently, of course, the budget had to be approved by supermajority votes in each house, and the budget bill became effective immediately according to the relevant constitutional provisions. Many budget items also required changes in substantive law to conform the law to the budget, and those changes were done in so-called trailer bills. Usually, at the time the budget bill is voted on, the trailer bills have not yet been fully written. To handle this problem, the legislature has gotten in the habit of introducing and moving through the process so-called spot bills that contain no content and are nothing more than vehicles to be filled in later in the budget process, usually after the budget has been approved. So after the budget is approved, final amendments are made to add the appropriate content to the trailer bills. Now, most trailer bills are treated as urgency legislation and also were approved by supermajorities, which, because of the supermajority vote, became effective immediately, just like the budget bill. Well, several years ago, the voters decided to reject the supermajority requirement for the budget bill. But that left intact the rule that urgency legislation normally still requires a 2/3 vote in both houses. Otherwise, legislation becomes effective January 1 of the next year. The question before the 3rd District in Howard Jarvis Taxpayers Association versus Bowen was how to treat trailer bills that relate to the budget process. Are those bills subject to the new majority vote requirement that is sufficient for the budget bill? Or do those bills now require a 2/3 vote? Well, for the 3rd District, the more precise question was whether the California Constitution, as amended by the voters in 2010, allows the legislature to identify blank bills with an assigned number but no substance in the budget bill, pass the budget, and thereafter add content to the placeholder legislation and approve it by majority vote as urgency legislation. Well, finding nothing in the constitutional language that really gets anywhere near close to describing that actual process used by the legislature, the 3rd District concluded that spot bills, which remain empty of content at the time the budget is passed, are not bills that can be identified within the budget bill and enacted as urgency legislation by a mere majority vote. According to this holding, only those bills that are identified in the budget bill as being related to the budget bill and which already have their substantive content can be subsequently approved as urgency legislation by majority vote. In essence, you can't amend a budget-related spot bill by majority vote after the budget has been approved. The court's holding is certainly a common-sense reading of the constitutional language and of the process that perhaps should be undertaken, but it does run counter to the legislature's long-standing practice. And if the legislature decides to seek further review, my guess is the California Supreme Court will grant review and give this issue another look. Next, we deal with an issue of municipal vicarious liability. When a police officer sexually assaults a minor, an activity that the parties conceded was outside the scope of employment, can that officer's employer still be held vicariously liable because the officer also breached his mandatory duty to report sexual abuse to a child protective agency? Well, that was the issue before the 5th District in KCS versus City of Turlock, where the plaintiff very creatively tried to turn the failure to report into a negligence claim for which the city of Turlock could be vicariously liable. But the creativity was just a little bit too much for the 5th District, which noted that if the mandatory reporting statute actually required the perpetrator to report his own acts of sexual abuse, then the statute would be unconstitutional as a forfeiture of the mandated reporter's Fifth Amendment privilege against self-incrimination. Accordingly, the mandatory reporting statute cannot be interpreted as requiring the perpetrator to report himself, and absent a violation of that statute, there was no basis for imputing liability to the city of Turlock. The 5th District affirmed the trial court's decision to grant a demurrer to the plaintiff's complaint. And finally, we have a case dealing with attempted unlawful assault weapon activity. Gun control is, of course, the big topic of the day. So I know that many of you have been wondering how you too could become the proud owner of an assault weapon. Well, believe it or not, you can always turn to the internet, where you can find semi-automatic assault weapon kits available at the click of a mouse. Websites that sell these kits also appear to provide guidance on assembling the weapons, as well as useful suggestions for avoiding criminal convictions arising out of the possession of the parts, their assembly, and even the possession of the completed weapons. But this really is a case of buyer beware, because if you follow through, you may find yourself convicted of attempted unlawful assault weapon activity and attempted possession of an assault weapon. In People v. Wynn, the defendant appealed his conviction, arguing that he couldn't violate the statute until and unless the AK-47 he bought was actually fully assembled and enabled the shooter to fire repeated shots without reloading manually. Well, the 4th District easily rejected this argument by noting that he was charged and convicted of only attempting to violate the statutes. Law enforcement and the courts do not need to wait until he was fully loaded, armed, and ready for action before arresting and convicting him of the attempt. And that's it for today's Kelso Report. Have a great day in the law.